10 seconds, 10 seconds. Ten seconds, 10 seconds, 10 seconds.
Good morning, Geauga County, Lake County, Northeastern Ohio. You are listening to the voice of Geauga, where every Monday through Friday, 7 a.m. to 8 a.m., you will hear Jonathan Broadbent, me, and a guest. This morning we have Matthew Hebebrand with us, constitutional expert, attorney, father, great guy, overall guy. And he's going to give us the background because we can't possibly document all the things that Matthew has done and is doing, and so we're going to let him summarize that for us all. But if you want to call into the program today, we're going to be talking about tariffs in the goofy Supreme Court. And thank God we should say a prayer this morning for the president that we've got, who was able to look the other way and find ways. He's got the best team I've ever seen as the president's office. It's just unbelievable. But if you want to call in this morning, 440-946-9468. And you can email us at voiceofgeauga@gmail.com. We are up and live streaming right now on Rumble, Facebook, and YouTube. And so if you want to take part and chat in any of those venues, then you can join us on one of those channels, Rumble, Facebook, and YouTube. So, and again, the call-in number is 440-946-9468. Before we kick this program off, I just have to make a comment to everybody. If you're following this property tax initiative, I attended last night in Geauga County at the Bainbridge Library a public forum, if you will, where public officials were giving people their viewpoint on the property tax initiative, and it was moderated by the League of Women Voters. I recorded the whole thing. I live streamed part of it. It's up on our channels. I will make this brief comment, and that is, what a joke. This is exactly why we don't elect the kinds of people that were at that panel meeting last night. And they droned on panicking and fear-mongering for over an hour. And I spoke up one time because I couldn't take it any longer. Brian Massey, who helped to start the whole property tax initiative, was there. And I said, allow Brian an opportunity. They kept saying, oh, there's no way to fix this. And, oh, my God, everybody is going to disappear. The teachers are going away, and the police are going to go away, and the fire department's going to go away. What are we going to do? What was us? What was us? And nobody has the answer. And I pointed to Brian Massey and said, well, we have the guy that started this. He's got the answer. Oh, shut up. And so it was nuts. And so anyway, anybody that thinks that this property tax thing, the public officials are being honest and forthright, you got another thing coming, and I filmed it, and I will show you exactly what these people are all about. We're going to have a program on it. Okay, I'm done with that. Sorry, I had to get that out of my system. Matthew is phenomenal. He's been with the Heritage Foundation, the Law Review. He's part of a law firm. He does other stuff. And so I want to turn it over to Matthew, but I think I'm going to flip it over to Jonathan first so he can say good morning to everybody. And then, Jonathan, why don't you introduce Matthew?
Good morning. Yeah, I brought a couple of things to the conversation, but I want to get Matt started first. So I'm going to turn it right back over to Matt. Matt, tell us more about what you were saying before the show started, about all the things that you've done that led to where you are now and what you're involved with now.
Thank you so much. I currently serve as a mediator with the Lake County Juvenile Court, but I've been involved in legal scholarship since I came out of law school. I originally worked for the Heritage Foundation, where I worked on the second edition of the Heritage Guide to the Constitution. And now it's already that point in time where they are coming out with a third edition of the Heritage Guide to the Constitution, which will be coming out later this year. I have several publications of legal scholarship, including a forthcoming law review article through the Capital Law Review regarding the Ohio Constitution. And in addition to that, I'm also of counsel with the firm of HV Legal, in which, among many other legal issues, the firm is dedicated to protecting people's rights under both the state and federal Constitution, with the tagline of clients first, Constitution forever.
Skip, if you don't mind, I will introduce something that I brought, and I think this will prove relevant to the conversation. And for me, it really kind of sets the stage. I've mentioned before, as somebody I follow online named Michael Smith. Michael Smith just yesterday, or actually the day before yesterday, posted something I screen captured. Since the American left insists on denying the morality of traditional America while using government to impose their will, I thought it time to further explore this quote from John Adams, written on October 11th, 1798. Message to the officers of the Massachusetts militia. We have no government armed with power capable of contending with human passions unbridled by morality and religion. Avarice, ambition, revenge, or gallantry would break the strongest cords of our Constitution as a whale goes through a net. Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other. To me, we've all heard that quote. Hopefully by now we've all heard that. That to me sets the stage for the conversation I hope to have today with Matt Heberbrand. Matt, I know that you know that quote.
I know that quote, and it was a sentiment shared by all of the founding fathers. They understood that a constitution is only really worth the value of the piece of paper it's on, but for the character of the people that govern themselves. Again, the principle of a democratic republic is that the people govern themselves, and if the people cannot govern themselves, it will either lead to anarchy or tyranny.
Exactly, spot on.
Well, and you've seen some of that, by the way. And so look at what happened in Minneapolis with our elected officials and what they did to stir up all of the chaos that existed in Minneapolis and all the people that are engaged in that. So you can actually see that. You see that across the country. Philadelphia did the same thing. Boston did the same thing. And so we've got immoral people. Sorry for saying it that way. If you want to call into the show, we've listed the number 100 times. If you're a Democrat, would you have stood the other night when President Trump said anybody that we're here to support American citizens and not illegal aliens? Would you have stood or would you have sat down? I'm asking you as a Democrat. Call our show, 440-946-9468. Anyway, I had to just go on that little mini rant. I apologize. But Matthew, let's get into the topic at hand. Oh, I think we lost Matthew. No.
Yeah, stand by, ladies and gentlemen. It looks like we've briefly lost Matthew. He'll jump back in and join us in a moment. But I want to drill down on where we need to focus our efforts. And I'm going to ask Matt this. It has everything to do with children. And we've known for a long time now with the whole how to defeat America without firing a single shot. It looks like Matt's joining us, rejoining us. But children are where we need to focus our attentions. We need to bring all of these concepts back into the education system, put them back. Civics, history, American government, Western civics, Western civilization, all of that needs to be brought back to recreate and reinstill that understanding of these basic principles. Don't you think, Matt?
I absolutely agree, and so I'm going to apologize for the technical difficulties I had there and coming off the program for a moment. But that will segue me into how I wanted to start talking about this case of Learning Resources, Inc. versus Donald Trump and the tariff case, because the way the media presents things doesn't do the reality justice, and part of it is having a real understanding of how the judicial branch works and what the judicial power is. When we talk about the executive, legislative, and judicial powers, the judicial powers are basically the applying a law or a set of laws to a particular set of facts. And so too often we have pretty much talked about the Supreme Court as being the ultimate arbiter of the Constitution. That anyone can do whatever they want unless the Supreme Court says otherwise, or we can't do anything unless the Supreme Court tells us we can do so. That basically sets up a judicial form of tyranny, and that's not the power that we have, the system of government that we have. I think Lincoln said it beautifully in terms of describing the power of the Supreme Court, that you honor their opinions, but each opinion is only relevant to a particular set of facts and circumstances. And so that is what a good lawyer will be able to use those to compare and analogize between facts and circumstances. But the general conception that the Supreme Court, says, is the ultimate judge of our Constitution and our constitutional structure is not the system that the delegates to the Constitutional Convention thought about when they walked out those doors and presented this new Constitution to be approved by the voters of each of the states at that time.
So that's a really interesting comment that you just made. I've never heard that said before, in terms of cases taken before the Supreme Court are decided on the particular facts associated with that case and not necessarily apply across the board or broadly. But the left would like to have law created through the Supreme Court, so they want this broad impact out of the court cases. So that's very interesting. So what do you think about this whole tariff case that the Supreme Court just found? Because I'm a fan of the tariffs personally, and the way that at least the way Trump is handling them, because they've been a very effective tool at reining in our adversaries or those other countries that want to game us a little bit. So what are your thoughts on that?
Yeah, so over the next half hour or so, I'd like to take your viewers and listeners through the opinion, explain the principles behind the opinion, and if time allows, I'd really like to get into the concurrences and dissents. And to explain why I want to get into that, there's additional background information I think your listeners need to be aware of. Again, because the way the media presents these Supreme Court decisions, they use phrases like the judges voted. Do we have 5 votes on the Supreme Court? They make it sound like the judges are part of a parliamentary group, or sitting at a ballot box for taking place in an election. The way
Matt, I'm going to step in right there. Unfortunately, we're coming up on a break. That provides us an opportunity to put the phone number out again. That is 440-946-9468. Call in and join the conversation, or find us on social media and post your questions. More on the other side of the break.
All right, I'm turning our mics back on. I'm starting a new practice where I turn the mics off until Thomas gives us the thumbs up. So the mics are on, so we can talk to our streaming audience. So Matthew, you're still on, but we're not broadcasting over the radio at this point in time. But
okay, yeah. So we're just broadcasting to the our podcast. There's an interesting comment here from Dorothy. We'll read that when we come back. So, Matt, I will ask you to continue when we come back from the break, and then Dorothy.
Anything that we want to give our streaming audience as a little bonus for streaming and watching instead of listening.
That's exactly right. Exactly. So, yeah, there's a lot to, and what people don't realize, and I'm hoping that we get to in today's conversation, is the various different ways and the various different mechanisms and laws through which tariffs can be applied. So that can be confusing. So people just think that it's sort of this lever. And I did have somebody comment a few days ago from sort of the libertarian wing of the political discourse that...
because the libertarians hate this. They're all about... we need free trade. They see tariffs as just a form of taxation.
Right.
And, and all taxation is bad.
Right.
So tariffs are bad. And I apologize for you libertarian streamers out there. I don't mean to make it sound like I'm, in any way criticizing that position. I'm just putting it out in a very
Well, let me jump in. Let me jump in and criticize that position, Matthew, for anybody who's a libertarian and thinks that. Having lived the tariff situation as I traveled and did business internationally, the rest of the world doesn't play by our rules, and so we can be, if everybody played in the same by the same set of rules, we'd be good, and I'd be on the libertarian side. But China doesn't
30
care.
seconds, 30 seconds.
And so they'll do a 100% tariff on our cars and prevent our cars and whatever from coming into China. And so you got to have some way to balance that. You have to bring them back to the table and get them to drop their goofiness to harm this country. And that's what Trump is doing, is he's applying a little extra pressure to be able to.
10 seconds, 10 seconds.
All right. So I'll stop that and then we'll go into a. That was my rant.
Welcome back to Voice of Geauga on WINT Radio with Skip Claypool, myself, Jonathan Broadbent, and today joining us as guest we have Matt Hebebrand. Matt, before we were interrupted by that break, you were talking. Continue your thread of talk.
Sure. So again, as just a piece of background information, I think it's important for your viewers and listeners to understand just a general aspect about how the judicial branch works. And this is true for any court, whether or not you're dealing with a court at the lowest level, at the county or municipal level, or the highest court, the Supreme Court. Courts speak through their judgment entries and their opinions. And so judges don't necessarily, they're in a way they are voting, but in a way they're not. What they basically do is that at the level of the Supreme Court, they write an opinion, and then each judge has the opportunity to sign off on that opinion. And that opinion is controlling. That means it has precedential effect, and that in the case of the Supreme Court, lower courts are obliged to follow the legal principles behind that opinion at the risk of being overturned by that higher court if they say something or do something otherwise. Only when 5 justices have all agreed on the same legal principle and signed off on the same legal opinion. And I go through that background because one of the important things about this case is not only the immediate effect that it has had once it came out last week on the tariffs that Trump had imposed, but for me as a legal scholar, I am much more interested in the potential future impact of this case and what precedential effect it has. And that has been mitigated by the fact that the main opinion, the opinion that was written by Chief Justice John Roberts, the main legal principles in that opinion were only signed off on by 2 other justices, Justice Gorsuch and Justice Barrett. Justices Kagan, Sotomayor, and Brown signed off on parts of the opinion, but the part of the opinion that really does the legal analysis and articulates the legal principles that affected the decision of this case, they didn't sign off on that, and they wrote separate opinions. And what's also interesting is that Justices Gorsuch and Barrett also, in addition to signing off on the main opinion by Chief Justice Roberts, they also authored their own concurrences in which they try and explain their understanding of the legal principle that's at issue here. And what I really like about Justice Gorsuch's opinion is that he goes through and he addresses every single justice. It's really an example of Justice Gorsuch attempting to engage in a debate to the extent that judges engage in debates. It's not like in Congress where they debate each other. They debate each other through these written opinions. And he addresses every single opinion, both Chief Justice Roberts' opinion, the concurrences by Barrett and Kagan and Brown, as well as the dissents. And we have 2 dissents here, one written by Justice Kavanaugh that was signed by Justice Alito and Justice Thomas. And Justice Thomas wrote his own dissent, and Gorsuch goes through it all. And the main issue here is this concept of the major questions doctrine. And I'm going to kind of go through how Justice Roberts explains this doctrine. But again, how Justice Roberts explains it is only worth so much because only 2 other justices signed on to this explanation. But the way that he puts it is that, you know, he goes through the kind of constitutional background, right? That we are our federal Constitution has limited powers, those powers that are just in Section 8 of Article 1 of the Constitution, and that when Congress is going to delegate or give the authority to issue rulings over those powers to the executive branch, that if there is going to be a huge grant, as they use the adjective extraordinary, if there's going to be an extraordinary grant of that power, that Congress would say so clearly in the law. And so part of the debate here between these justices is whether or not this major question doctrine has any legs. Because the Justices Kagan, Sotomayor, and Brown don't believe in the doctrine at all. They have consistently, in their rulings, dissented on major questions cases, and so part of the issue here is does this have any legs? A corollary to this, which also explains the dissent and and Justice Gorsuch's concurrence, is the concept of non-delegation. And non-delegation means that there are certain legislative powers, right, that only the Congress has. Again, we're talking about the separation of powers. There's the executive, legislative, judicial. The non-delegation doctrine basically says if there are legislative powers, Congress cannot delegate any legislative powers to any other branch, whether or not it be the executive or the judicial. And those are 2 distinct concepts. That the non-delegation doctrine is a legal principle that will strike down a law based on the improper granting of legislative power to another authority. And the Supreme Court has not struck down a law on this basis since the Great Depression, since the switch in time that saved 9, back in the FDR days, and the turn from having a very strict contextual Supreme Court to a what's seen as a more liberal Supreme Court that's gone on since you have basically until the Rehnquist era. And but still, we had a couple opportunities within the past couple of years to revive that non-delegation doctrine, and the Supreme Court hasn't been willing to do it. What they've turned to instead is this major questions doctrine, and it is different in kind because it is a form of it's basically seen as a canon of statutory interpretation, which means instead of looking at it from a constitutional perspective, there's a constitutional background in mind. But instead of ruling on a statute as to whether or not a statute is constitutional or not, it is really looking at the executive action itself. In this instance, the executive action is the imposition of tariffs under the International Emergency Powers Act, and whether or not that action conforms with the statute, with that IEEPA statute. And so it's looking at the statute itself, and it's a method of interpreting the statute. That's what a legal canon is. A legal canon is a method of interpretation. And so basically how it applies is that when the judges will look at a statute, they will say, is this statute in any way ambiguous, or does it ambiguously grant authority to the executive branch in such a way that the executive branch can take onto itself more authority than the statute would give, given these background principles, that if Congress is going to give a huge amount of authority to the executive branch, it would say so in clear terms. So that's kind of how this doctrine has been used over the course of the past couple of decades. And it's been the go-to for the Supreme Court to declare an executive action unconstitutional, rather than addressing the bigger question of whether or not the statute itself is unconstitutional under the non-delegation doctrine.
So, Matt, we're coming up on a break. We've got a little under a minute. I want to pause for the sake of our listeners. And Darafi, stay tuned. I am going to interject your question when we come back from the break. But, Matt, it occurs to me to ask on behalf of our listening audience, where can people turn to learn more about this? A lot of what you're talking about may seem a little strange and a little foreign, and you're using terminology that is not natural and not native to a lot of American discourse. Are there resources, Heritage Foundation and others, that you would suggest people turn to? And I think when we come back from the break, we'll lead back in with an answer to that question. Remember, you can join the conversation at 440-946-9468, and we'll come back with more on the other side of the break.
So, yeah,
Thank you.
this is fascinating, but I'm going to add on to Jonathan's question. When we come back, I'd like to comment on that. But what can we do to change people's thinking on this? Because they hear the news media come out and say, oh, my goodness, the Supreme Court gets to rule and make legislation, basically. And everybody thinks that that's the way it's supposed to work in our society. How do we change that?
No, the way the media is portraying this is like they got together like a little mini Congress and voted 6-3 against Trump.
Yes, exactly right.
That's not how it works.
No, I'd like to have you say that when we come back from the break, and we can lead you there in some way. But that is exactly right. The average person just doesn't understand, because the average person doesn't know we have three branches of government. But
right,
and really,
including AOC.
And what I'd like to get to, and that your streaming audience will hear now, is that what was important to the Supreme Court justices in this case was not the tariffs itself. What was important for them about this case was the legal impact of how to apply this major questions doctrine. That's what matters to them. They are always thinking about precedent. They are thinking about the precedential effect of their opinions. They are thinking of how this case is going to affect cases like the Jerome or the Lisa Cook case, right? Because part of that is, again, the what authority has Congress given the president to fire his employees? Right? Is that authority that Congress is given? How do we interpret the statute for the Federal Reserve Act and the various statutes, the amendments that have been made to that over the years that touch upon President Trump's authority? They're thinking about other cases like that. They're not thinking of tariffs good, tariffs bad. We need to strike this down because tariffs are bad. That is not how they're looking at it at all.
Yeah, and the average person doesn't go there.
Yeah, the average person doesn't understand
no, so that's
it,
how
and
the media. That's how the
media.
media portrays it. The media portrays everything from this Trump-based lens that something is either good for Trump or bad for Trump, and then we talk about it in that context. That the Supreme Court, ruled against Trump. The Supreme Court is, setting up a battle against Trump, and the media loved. They were just waiting to panel the Supreme Court justices at last night's State of the Union to again set up this battle the same way that they did when Barack Obama called out the Supreme Court for the Citizens United case about 12 years ago. And I think a lot of the people in the media were disappointed that Trump didn't use stronger language in his State of the Union address regarding this case, because they wanted a moment just like they got when
30 seconds.
When Justice Alito mouthed, "That's not true," and I don't think Justice Alito has been to a State of the Union address since that.
Yeah, so the
10 seconds.
Welcome back to Voice of Geauga with our special guest, Matt Hebebrand, talking about our Constitution and Supreme Court rulings, what they mean, and an important element of today's conversation, the media's portrayal of what happens on the Supreme Court. Before we went to break, I was asking Matt for resources for the average citizen to familiarize themselves with this landscape, because let's face it, our media doesn't do a very good job of adequately presenting the facts around Supreme Court. What are your thoughts, Matt, on public resources?
Yeah, again, I'm very partial towards the second edition of the Heritage Guide to the Constitution. I recommend all people to buy that, or if they want to wait another couple months, they'll be able to get the new third edition of the Heritage Guide to the Constitution. The Heritage Foundation, of course, like everybody else, has a website that has more up-to-date information that is presented to the lay people. And part of the problem is that our industry, the legal industry, is kind of trained to kind of talk within that industry instead of presenting information to what we refer to as the laity, people who aren't lawyers, who aren't legal scholars, who aren't legal educators, and that's part of the problem. And there are plenty of other resources out there, but like I'm a member of the Federalist Society. Thinking of recommending the Federalist Society's website, but a lot of that is again geared towards information that's geared towards other attorneys, which is why I think it's important for me to participate in programs like this, so I can at least try and attempt to explain these concepts to the people in a way that is appropriate for them, to get them to understand, instead of keeping things shrouded in mystery and allowing the media to misrepresent what's going on legally. And we started having a conversation outside, during the break, that I believe it's important to reiterate, is that the media has presented this as a case against President Trump, has made it a case really about the Supreme Court deciding against tariffs, which in one sense, and the Supreme Court says this, that the case is not on the wisdom or the prudence of implementing tariffs in general. Again, it is talking about the implementation of tariffs under this particular statute. And the reason that the Trump administration chose this statute is because there are about a good dozen different statutory provisions, maybe even more. I haven't gone through them all to count them all out. But there are plenty of different statutory provisions under which Trump can unilaterally impose tariffs. But many of those different statutory provisions come with different conditions. He might have to perform an investigation first. He may have to notify Congress of certain findings of fact that his administration has made before he imposes them. They might also come with different timelines. He may only have a 30-day or 90-day or 6-month timelines for tariffs. This particular provision basically allowed him to declare an emergency, and of course Congress could try to basically override that declaration of an emergency, but then that resolution to override the emergency would have to be passed by both houses and could be subject to a presidential veto. And your viewers might not be aware that there were people in Congress, at the beginning of last year, who tried to override this declaration of an emergency, and it didn't get anywhere in Congress because we have a Republican Congress, and even if it had, Trump would have vetoed it. So, and that comes up in this case because it did motivate the individuals who signed off on the main opinion as to their implementation of this major questions doctrine, because they basically said that because Congress did not use the word duty or surcharge or other words that they have used in other places in the same statute that were used explicitly towards tariffs, that in this statute they must not have meant the authority of imposing tariffs under this statute, because these other statutes that have these different requirements, these different timelines, use the word duty and surcharge. And those are the words throughout the statute that really mean tariffs. And one of the important legal issues here that members of the dissent quibbled with is the fact that the main opinion basically characterizes a tariff as a tax. And so, as an originalist, I think that opens a question of originalist interpretation, and the different opinions get into this because the founders used different, basically talked about internal taxes differently than external regulations and duties and surcharges and customs. Custom in the sense of imposing a custom fees on the import and export of goods. So that gets bandied about in this opinion. But I think at this point it might be a good opportunity to get into the question that one of our listeners had posed.
Yeah, I was just heading there. So we've got Darafy on Rumble, who makes the point, I think, that Trump undermined his own argument in the SCOTUS for using the act for tariffs when he started using tariffs as a sanction-like function for things not under national security. She goes on to say, he or she, I'm not sure who Darafy is, I am a fan of Trump's and tariffs, but I think he made a mistake this way. What do you think of that?
I think there's a point to be made there, but that was basically what Trump was trying to do. And what's important for people to realize is that when Trump basically has a number of audiences when he speaks, right? He's got Congress, and when he knows that a case is going to be challenged, and he has the judicial branch, that he also has to be aware that any comments that he makes, any actions that he takes are going to be used in those cases. But he also has the general public, and he's got to win the general public over, regardless of Congress or the judiciary, because then if he has that popular approval to do what he wants to do, he can make the argument that, I can defy Congress or the judicial branch because this is what the people want. And so part of and in this case, in addition to those internal audiences, he's also got an international audience. And this is really where Trump is coming from in the imposition of his tariffs, is that he has been using tariffs as leverage in his international negotiations. And this is something the dissent really highlight, because in Justice Thomas's view, this is something that is a prerogative of the executive branch to do. And he makes an originalist argument that breaks down that difference between internal taxation and the prerogative powers of the King of Great Britain. And the understanding was that the imposition of tariffs on foreign imports is something that is a foreign power that the president has in the executive branch. And even though the Constitution has explicitly granted that power to Congress, it is in effect an executive power that has been placed within the legislative branch, that when that legislative branch delegates it back to the executive can do whatever he wants with it, which I find to be a very fascinating interpretation of the tariff authority. But Justice Thomas is the only one who went that far. And so I think if there was a mistake the Trump administration made in terms of arguing for the Supreme Court, is that they didn't make that argument that Justice Thomas meant, and in fact they explicitly said that his authority is based on the historical background of presidents imposing tariffs in wartime rather than peacetime. And what this particular statute do is that it makes a distinction, but not between wartime and peacetime, but it includes a kind of middle category in which the United States isn't technically at war, but there is some international emergency that should give the president this authority. And so the historical antecedents to this, in terms of presidents in the 19th century imposing tariffs during like the Mexican-American War and the Civil War, That was kind of the authority that the Trump administration pointed to, and then said now. But in this statute, Congress basically took that wartime authority and applied it during peacetime, when the president declares an emergency. And the majority opinion basically used that against the administration, so that the administration has never pointed to a prior time when a president has imposed a tariff during peacetime. And in fact, the administration concedes that during peacetime it would not have the authority to impose tariffs.
Yeah, but we all know that there are certainly circumstances outside of either war or peace, like Cold War, for instance. There are Cold Wars that take place that are just simply adversarial relationship, and we're in one right now with China. China and America are competing in a number of different levels. We're heading into a break. Before we go into break, I'm going to pause to recognize the sponsor of the show, and that is Great Lakes Outdoor Supply. Don't forget to stop into either the Middlefield location, that's the larger of the two, or Chesterland Great Lakes Outdoor Supply. There are great, fun resources for the outdoors person. Great Lakes Outdoor Supply is a terrific resource to Geauga County and surrounding area. Remember, you can dial in, join the conversation at 440-946-9468. We'll come back with more on the other side of the break.
Yeah.
Mics are off.
Durfee's absolutely right. I'm surprised, too, that the folks are still watching corporate media, because they completely distort everything, for that matter. But in this situation, I mean,
Oh my gosh, yeah, especially now. And then there's so many people that have woken up to it. And it's mystifying to me. I've commented before, and you see people that come in from places like communist China, and they're astounded by the idea that Americans still actually pay any attention to what comes out of the TV screen. It's so closely aligned with government narrative, and it's, to most people, everybody that I'm aware of and bothered to pay attention to and interact with, it's plainly obvious. And that's, I mean, there may be no better example than Supreme Court rulings. Matt?
Yeah, I really, one of the things that I wonder about is how true that is in a digital age. And I think there's definitely a generational difference between people who watch the mainstream news networks and people who get their media mainly through online, whether it's through websites or more than anything else at this point is social media, right? Yeah. And one of the ways that the mainstream media has
30 seconds.
uses, we're coming up on 30 seconds. I'll have to save my thought for another time.
Ten seconds.
Hey, Jonathan, flip it over to me real quick when you come back.
Welcome back to Voice of Geauga with Skip Claypool, myself, Jonathan Broadbent, and our special guest, Matt Hebebrand. Skip, you had something you wanted to say.
Yeah, I did. I just wanted to point out to people, we go into these breaks, and we're still live streaming, and so we have a fascinating conversation in the live stream audience with Matthew and the folks that are on our live stream. And so if you want to take part in that live stream, either Facebook or Rumble, right now Rumble is the most popular, or YouTube. But while it's not being broadcast over the radio, if you're in our radio listening audience, you might want to plug into our live stream channels, because we have some fascinating break discussions, and we were having one of those. I'm really impressed, Matt. We got to get you back more often, because you're just a wealth of information. We can't absorb things quickly enough coming from you. So anyway, back back to you, Matthew. Go ahead and continue the explanation that you were giving us about before we went into the break.
Sure, and I think I'd like to return to a point I can't emphasize enough, is that as much as the media wants to construe this case as being a case of the Supreme Court against Trump, or the Supreme Court decides against tariffs, the way that the justices have actually viewed this case, and the way that legal scholars are going to take this case apart, and why it's important in the legal industry, is because this case was about more than just tariffs, and it was about more than just this particular statute. What made this case so important was because this case was the potential of this case to use as precedent regarding this major questions doctrine. As an originalist myself and someone who spent my career, studying, the federal Constitution in particular, but also the state Constitution, studying how our legal history, that when we talk about presidents appointing Supreme Court and having Republican appointed judges and Democrat appointed judges, what matters more than the partisan affiliation of a judge is really their legal philosophy. And I am a sincere believer that our judicial branch has gone off course over the past decade because they have taken kind of what we call a living Constitution view of what the Constitution means, which is basically that the Constitution should be interpreted in a very liberal way, not liberal in terms of left-wing versus right-wing, but liberal in terms of a loose rather than a constrained view, to adapt to the times. As times change, the Constitution should change with it. And originalism is a legal movement that basically started in opposition to this. It saw what the Supreme Court was doing in the 50s and in the 60s in this regard, and said, hey, this isn't how our judicial branches interpreted the Constitution for its first 150 years or so. We need to go back to how the Constitution was interpreted, not just at the moment it was adopted in 1787, but that consistent interpretative methods for the first 150 years of its existence. And that's basically what originalism is. And over the course of the past 3 or 4 decades, that has been the real battle in the judicial branch. More than a partisan battle, it's been a philosophical battle on legal interpretation. And that's really what this case represents to the justices, is that this was a collision between in what way do we effectively interpret this kind of statute in light of the Constitution, and how is that going to affect future cases down the pipe? Because with this administration more than any other Republican administration, more than either of the Bush administrations, more so even than the Reagan administration, which really had a profound impact, particularly under Attorney General Ed Meese, on really making originalism a thing. Right? The only reason we have the Supreme Court justices we have on the bench today is because of the appointments the Reagan administration made 30 years ago. Because again, typically you don't just get appointed a Supreme Court justice out of nowhere. You literally rise through the ranks of the judicial system. But he had to start making appointments at the lower court levels, and we've got 30 years of originalist judges being appointed at the district and court of appeals level. The court of appeals level in particular is where the president can have much more discretion in terms of his appointments. And that's where we are today. And so the justices were really looking at this in terms of how do we appropriately interpret the statute to be in line with an original understanding of the Constitution. And you have the stronger originalists, like Gorsuch, like Thomas, who are willing to give some peace to this non-delegation doctrine. And that's really where the concurrence and dissent come into play. But we don't have a majority of justices willing to go there. This concept of a major questions doctrine, and again, the differences between the two the way that I would phrase it is that the non-delegation doctrine is looking at the statute itself, whether or not the statute is a constitutional delegation of legislative authority to the president, whereas the major questions doctrine is looking at the executive action itself and seeing whether or not the statute authorizes that action. So it's one of the reasons that the justices like Barrett and Roberts have favored the major questions doctrine to the non-delegation doctrine is another concept which is called constitutional avoidance, which is that the judicial branch basically is encouraged rather than trying to make everything a constitutional case, right? If there is a more limited way of overturning either an action, an executive action, or a statute, rather than declaring the statute unconstitutional, they'll take the less impactful means of overturning it. So the major questions doctrine is another instance of this constitutional avoidance. Rather than ruling on the constitutionality of the statute, we will interpret the statute in such a way to make it constitutional. That's basically what this major questions doctrine does. Instead of interpreting a statute to unconstitutionally delegate authority, it will ask, assuming that Congress cannot delegate certain authorities, has the statute been worded in such a way that the executive could take more authority than what's needed?
So let me jump in there, Matthew, because we're coming up to the end of the program. I'm watching the clock tick down.
Yep.
You can't see it because you're not on the line. But if you were a Supreme Court justice, where would you have fallen?
I'm not gonna rule either way on that.
Oh, you're tap dancing there, Matthew. You're tap dancing.
But
Maybe he's setting
what
himself
I
up.
think is important, and this is the note that I'll leave your listeners off on, is another important point that I make, and this is why I act as a mediator, right? Is I think there are some things that judges just shouldn't decide upon. And one of the things that the dissents get into, which I didn't, I don't think were fully articulated the way that I think could have. I think the Trump administration could have made an argument that this was basically a non-justiciable question, that because of the implications for foreign affairs and because of the authority that Congress inherently has, that this is basically a political question that should really just be hassled out between Congress and the executive branch. That the founders basically had a narrow category of cases that they believed would be brought before the judicial branch. And over the course of the past 50 to 100 years, we have allowed the judicial branch to take on much more authority than I think is due and proper. That there are a lot of cases.
That is a very valid point. Unfortunately, we are coming up at the conclusion of this show. We've run out of time. Matt, I hope you'll come back again soon and join us and continue this and similar conversations around our founding documents and Constitution. Thanks, everybody, for tuning in.